and the Victims' Council. Plea has already been taken in this matter, and in view of Article 49(1)(h) of the Constitution, the accused person is entitled to bond, unless there is sufficient reason why has been advanced why it is to be denied the same. The ODPP is not opposed to bond being granted, but has asked for the court to place stringent terms, including the accused depositing his passport in court. The Victims' Council too have raised their concern as to bail bond terms and also addressed the issue, court on the issue of jurisdiction to hear this matter. First and foremost, it is the ODPP that made a decision to charge the accused person before this High Court. This is an independent decision made, and the same can be questioned through a formal application which should be filed for consideration by this court after submissions made by the parties. Secondly, having found that bond is a right under Article 49(1) of the Constitution, and same not having been opposed by the DPP, I do grant the accused person on bond of Kenya shillings 2 million with one surety of similar amount, or in the alternative, I'll grant him cash bail of 1 million shillings. The accused person by himself, his agents, and proxy will not contact any of the witnesses or potential witnesses in this matter. The accused person is restrained from visiting the area where the incident occurred or its vicinity during this trial. The probation department Thika is directed to file a prevent report containing victim sentiments, and this court reserves the right to review bond terms based on the same. This report will be filed within the next 30 days. Both parties are encouraged to restrain themselves and not to discuss the merits of this matter in political forums. So, mention.
First, I want to convey my condolences to the family of Mr. Ndwati, because in all these things we know that there's a family that has lost a loved one, and I have not had an opportunity to send my condolences to that family, and therefore I take this opportunity to first give my condolences to that family as they bury their loved one tomorrow. Secondly, I have taken a plea of not guilty before this court today, and this matter is now perfectly before a court of competent jurisdiction, and therefore I trust that the judicial process is going to take place and everyone is going to get justice, as that is the work of the courts to ensure that they deliver justice to everybody. Number three, I want to thank everyone, my friends, family members, and members who have stood with me as colleagues, who've come to see me when I was incarcerated and held. People who gave me encouragement, especially the people of Gatundu South, who have also stood with me during these very trying moments, and who continue to give their confidence in me as their leader. And I want to assure them that nothing will stop. Service to them will continue. I will continue serving the people of Gatundu, and especially the people who are very worried in the tea sector. I want to tell them that their justice will be served to them. The forthcoming political processes of the elections will not be derailed by people trying to misuse the judicial system, trying to walete kesi, wanifunge, wafanye hiyo maneno yote. Haki ya mkulima wa majani chai katika hizi elections zinakuja za mwezi huu ni lazima itapatikana kwa hao.
What new do you want to say?
What we want you, we don't want you to mark your records, so that this when you. But we want to put this in the background of Article 50 of the Constitution on a fair hearing. These are the rights of the accused, which also extend to mean the rights of all the other parties involved. And Your Lordship, the victims feel that these offenses took place in Thika, and they feel that the public that has a nexus to these events is in
He allowed his passport so that he can perform even as we stand, we wait for the trial. That's all. For the court, that every time the accused person has to travel, he has to come here and make application for his passport and all that. Your Lordship, we are saying he is not a flightless, he remains not a flightless. There is no good reason that has been advanced by the prosecution to have him surrender. To reply to the submissions from the prosecution about the surrender of the accused persons. The Lord has noted earlier the accused person is a member of parliament. It is not like this.
If I can cite just a few cases that have been registered in a place where the commission of offense was not committed, beginning with the case of the Bible. Yeah. Because this seems to challenge the decision.
One terms. My Lord, each case is treated on its own merits, unlike what learned counsel is suggesting. My Lord, in balancing the rights of the victims, section
equality before the law has no rider, whether it is a charge of murder, whether it is a misdemeanor, it has no rider. All parties are equal before the law. My Lord, and on the last issue which the state has addressed, on the issue of jurisdiction, the court had already addressed itself on the first day of the year and directed that if any party has an issue on jurisdiction, they can make a formal application. Only to add that, my Lord, the court can take judicial notice that the times we are in are times that we are digitally connected. My Lord, I can see the screen before us. Bariki Jumatatu is a friend of mine. His office is in Nairobi, but he is present before court. So, my Lord, wherever the court sits, as we stand, every person from any corner of the world is able to follow the proceedings, is able to be part of this proceeding. Those submissions, my Lord, we urge that.
Or I that you consider pleading to reasonable boda and pleads. The issue was raised about the state council talked about the issue not being addressed in a public forum. And my colleague for the victim expounded.
for us.
Check it.